Welcome, everyone. We will formally start the interview portion of our Business as Usual webcast. I want to welcome Damien Riehl, the lawyer, technologist, and the managing director. Managing director, is that the
That's
official
right.
title of Fast Case? Fast Case is our um, uh, legal research platform that's available to all members. As I said, originally we had Thomas Hamilton from Ross Intelligence scheduled. As we were saying just a moment ago, we swapped him out for June 17th. We rescheduled Thomas. But very, very happy to have Damien with us, also for copyright related issues. Damien's been talking to us for a little while now about his, and I'm not sure what the official title is. I've just called it the Melodies Project. Does your project have a official title?
We do. We actually have a Minnesota limited liability corporation called All the Music LLC. So this is the All the Music Project.
All the Music Project. All right, so great. So why don't you start just with a quick introduction about who you are, and then tell us a little bit about all the music.
Sure. I'm Damien Riehl. I've been litigating since 2002 or so. I clerked for Chief Judge Toussaint at the Minnesota Court of Appeals, Chief Judge Davis at the Federal District Court, and then for a decade I worked at Robbins Kaplan, litigating large commercial disputes, breaches of contract, that sort of thing, as well as copyright, trademark, and patent issues. Did that for a decade. Pitched Thomson Reuters. I said, "Here's software that can change the world. You should build it and hire me." So they did, and I led a really large team on a really large project building software. After that, jumped to cybersecurity, where I did engagements where I would somebody would get popped, and I would go in and with my tech guys and figure out who popped them and how they could get the bad guys out. My biggest engagement with them is that Facebook hired me and my company to investigate Cambridge Analytica. So I spent about a year and a half of my life on Facebook's campus Monday through Friday, working with some machine learning folks and data scientists, figuring out how bad guys were using Facebook data. During that project is actually how I came to the All the Music Project. So that I'm going to be talking about a bit. But before I get to the All the Music Project, after Facebook, I joined Fast Case as the managing director, where I oversee our forward-looking projects. So building AI into the product and being able to do some really cool things that I'm really excited about, but can't talk about yet.
Yeah, I'm eager to learn about those projects. My colleagues and I have always discussed you were ripe for that kind of partnership, and eager to hear what's coming down the path. So we were excited to hear about that partnership. Yeah, so tell us about all the music in the world.
Sure. So some other background that I didn't mention is that I'm also a musician. So I have a bachelor's degree in music education. So I was going to be a choir director, and I have also a double major in voice and percussion. So I've been a musician my entire life. In law school at Mitchell, when I went there, my copyright law class, I was struck by the George Harrison case. And for those who don't know, that he was sued by the Chiffons for "He's So Fine." That's what the Chiffons had, versus George Harrison's "My Sweet Lord." The Chiffons sued him, and George Harrison lost and at trial for subconscious infringement. And so that always stuck in my craw while I was at Mitchell, saying, how can somebody subconsciously, essentially be punished for subconsciously doing something? Almost every other aspect of civil or criminal law involves some mens rea, right? That you have some intent to do something. So for that court to say that you did it, you just didn't know that you did it, that always struck me as very unfair. And so fast forward to the Facebook engagement, I just spent 16 hours on Facebook's campus, went back to the hotel bar with one of my brainiac computer scientist colleagues. And I said, know what, I knew that you could brute force passwords. That brute forcing, for those who don't know, is using a computer to really quickly guess your password. So the computer goes AAA, AAB, AAC, AAD until it hits your password. That's called brute forcing. So I said, Noah, in this hotel bar, I said, Noah, we could brute force music. We could go da 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 re da 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 mi da 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 fa, and just mathematically exhaust every melody that's ever been. He's like, F yeah, let's do that, in a way that only a computer programmer can say, F yeah, let's do that. And so in 2 hours, he had a prototype where he had generated hundreds of thousands of melodies, just brute forcing it. So we initially thought of this as kind of a lark, like, oh, wouldn't it be fun to, how many do you think we could actually brute force? And under the copyright law, I did some copyright law as a lawyer, and I taught at Mitchell Hamlin several semesters of copyright law. And so I know that if you can only to copyright something, you don't need to formally register it. All it needs to be is in a quote fixed tangible medium. And so I thought as soon as it hits the disk, that's a fixed tangible medium that is copyrighted automatically. You don't need to do any formal registration. So it occurred to me that as we're making these billions of melodies, so our first data set was 68 billion melodies, all 68 billion melodies conceivably are copyrighted. And so that led to an interesting philosophical and maybe legal question as to, of those 68 billion, some are under copyright today and some are not. And so so the interesting question is, have we, just by pushing these 68 billion to disk, infringed every existing copyright that has ever been? And in the future, for those open spaces, is everybody else who hits an open space from now on infringing us? And so that's really, it brings to the fore kind of the absurdity of these "you stole my melody" copyright cases like George Harrison had, because we demonstrated tangibly in a way that was kind of only philosophical in the past. What if you accidentally stepped on somebody else's melody? What is the likelihood of doing that is the philosophical question. But we put that in actually tangible terms. In actual, when the wheels hit the road, of do, re, mi, fa, sol, la, ti, do, of 8 pitches of length 12, there are 68 billion of those. So we took a philosophical question and made it a tangible question that has a real answer. And that's so anyway, so it went from kind of a lark, do you think we can actually build all the melodies, to something that we think that actually can change the law for the better, to be able to start these absurd "you stole my melody" lawsuits, when really our point is there's only so many notes in the melodic scale, and the odds of stepping on them are too high to be able to punish people for subconsciously infringing.
Yeah, let's talk about the subconscious infringement, which could happen in the patent universe, right? Because you have to do a prior art search. You don't want to step on anyone else's intellectual property. But in the copyright world, really there is no such thing. Well, practically there is. I think it was the entertainment law section called the Blurred Lines case the worst copyright decision in the world.
Amen.
And because it emulated the style of Marvin Gaye, right? If I were to stand right next to you and take a photo, and you took the same photo at exactly the same time, those are two independently created images, though if you were to compare them, they would be substantially similar to one another, correct? Still, though, as a matter of law, those are two independently created works I could acquire and register for and have automatically by fixing it in a tangible medium of expression, in independent copyright in my image, you and yours, correct?
That's exactly right. And so there's so that is a really good example of the photography. Two photographers standing inches from each other can have independent copyright in there. Similarly, two authors who write the same sentence independently, who don't even know each other, those independent sentences are independently copyrighted for each of those people. Because for copyright infringement to happen, you have to show "quote unquote" copying. You have to show that person A or person B copied from person A. That's but with for those two things, photography and words, it's harder to accidentally step on somebody else's the same thing than in music, because if you think about words, just the math is so much bigger. The math on the music side is do, re, mi, fa, sol, la, ti, do. That's 8, and then you have how many pitches repeated. That is, we'll say 10 repeated pitches. So that's the math on that is 8 to the 10th power. So that's so 8 to the 12th power. So that we repeated 12 notes is 68 billion. So anyway, so math is 8, however many pitches by the repeated notes. So if you apply that to words, there are 117,000 words in the English language. So if you then say even for 5 words strung together at the same time, the math on that is 117,000 to the 5th power, which there are more sands, there are more grains of sands on the earth than that number of possibilities. So 68 billion seems like a big number, but compared to words, for example, it's really remarkably finite. And then if you take an even shorter phrase, like the "My Sweet Lord" melody is 3 pitches to the repeated 5 times. So the number of combinations there is 243. There are only 243 3 pitch 5 repeated note melodies. So if there's only 243 of them in the history of humankind since the beginning of time, should we give any one musician a copyright in something that there's only 243 of in the history of the universe? So the part of the goal is to make people think mathematically about music in a way that is not, it's unique to music, because every other art form, visual art, words, there are near infinite possibilities. But with music, it's remarkably finite.
So question for you in regards to the notes and the number of, I think you talked a little bit about the number of notes that you had programmed in, but one question is, the length of those notes or rests in between those notes, do versus do, 2 different things.
Yep.
Did the program that you guys created take into that account? Does copyright take that into account?
That's a really good question. So I'll take the copyright question first. The question, as Mike alluded to earlier, is, are the 2 melodies substantially similar? So the copyright law to infringe on somebody doesn't require exact similarity, the same rhythms, because, for example, the Chiffons and George Harrison, they actually had different rhythms, but the court found that they were substantially similar, even though they had different rhythms. So going into this All the Music project, I argued that, that just because we had quarter notes was our what the software world calls minimum viable product. We wanted to put out a minimum viable product of quarter notes, and now we're actually integrating rhythm. But even with the quarter notes, does rhythm matter as much as the change in pitch, which is the real thing that I think for music infringement, because there's a common "You Stole My Melody" from everybody that everybody knows is "Twinkle Twinkle Little Star," which is the same as A B C D E F G, which is the same as "Ba Ba Black Sheep, Have You Any Wool?" If you look through that melody is 100% the same, but they are different rhythms. And why do they have different rhythms? Because they have different words. A B C D E F G, ba ba black sheep, have you any wool? Right? It's the same melody, but they're different rhythms. So really, this gets to the philosophical question. They are substantially similar, right? If Ba Ba Black Sheep were sued by Twinkle Twinkle, they would lose because that's the same melody. So because they are substantially similar. So it gets to the philosophy of what is a melody. And I would argue that the rhythm matters much less than the change in pitch for the legal purposes. Of course, rhythm is really important for music appreciation purposes. Arguably, it's second only to the change in pitch as to whether the most important thing. But for rhythm, the law, it doesn't matter. That's all to say that our most recent data set actually incorporates rhythm in that the number of pitches, we have 12 pitches, the 12-tone scale, and then the 13th pitch is actually silence. So that's how we've incorporated rhythm into it, so that now so it has whole notes, half notes, quarter notes, dotted eighth notes, really every up to the 16th note, every combination rhythmic thing.
So I'm also curious in regards to copyright aspects, because you had talked about whether or not you just infringed on every song that was made prior to your program. And so my question becomes, does copyright, and I don't practice any copyright, I do criminal defense. My question is, does copyright pertain to only things that are essentially published? Is there a requirement that you're trying to make money off of it? Anything to that extent, so that, essentially by creating everything, you haven't infringed because you're not putting it out there? Is there any aspect of that?
Yeah, I would say that. So we have actually put it out there. Part of that is we've distributed all the melodies. I'm kind of tempting anybody who wants to sue me. I would love. My wife said, "What if he gets sued by the big record companies?" I said, "Oh, there would be nothing better than to be sued by the big record companies." I would love that so much, because I've spoken with Stanford, Harvard, Cornell copyright professors who would be happy to represent me pro bono in that lawsuit. And think about, for the record companies, what do they have to gain by suing me? Because I'm not making any money. I've made $0 on this, and all they have is loss. Because if they get a court to say that every one of my 68, well, now 200 billion melodies is copyrightable independently, that is certainly not to their benefit. So one is the practical aspect. Are they going to sue me? Probably not. Secondly, could they sue me is another question, and I would say arguably they could. My response to that that lawsuit is that I've used a computer to crap out in literally a week 200 billion melodies. So is that something that we want to give a monopoly, a government provided monopoly for life of the author plus 75 years for something that a computer spit out in literally a millisecond, less than a millisecond? And so I would love to make that argument in court.
It's interesting because I think you mentioned on your TED talk that the copyright system is broken, and so often this is how we see the change in copyright laws. Please sue me, right? That's what Carl Malmuth did with the Georgia Code. He said you can't copyright this, so I'm going to copy it. Please sue me, right?
Yeah.
And that's how we're legislating copyright these.
That's right. And Carl, I don't know if you just saw just this past week, and maybe this week, I forget which, but he just bought right next door is the Wisconsin jury instructions that they sell. He just bought the Wisconsin jury instructions. That's the next target in Carl Malmuth's. I guess he's in his sights to be able to attack jury model jury instructions.
He's done that as well, and with the building codes, which are incorporated by reference into most state regulations, and you have to pay for those, right? Those are also behind a paywall. And I hadn't thought about it, but the most recent Supreme Court decision, which found in favor of public resources, Carl's, probably impacts that rule as well now, right? I mean, that's got to be. I'm sorry. I want to make sure that
as a full disclosure, Fastcase was a amicus brief in that Supreme Court case, and
yes.
So just as a full disclosure.
Yes.
So speaking of amicus briefs and jumping back to the copyright issue, my question is, eventually we're going to have a lawsuit post creating all of these melodies, and I believe that you stated at one point that you put them in the public domain. Eventually there's going to be a lawsuit from somebody out there that says that not only did they create their song after you did this, they're not going to mention you, of course, but then they're going to sue somebody else saying you've infringed on me. Is there any intent or desire, or has anybody reached out to you for amicus briefs saying, hey, you want to come in here and actually correct this and say that you were the original copyright owner on this?
I think you're 100% right that is going to happen. Or at least if there are lawsuits going forward for the "You Stole My Melody" lawsuits, which question whether that actually is going to happen based on recent Ninth Circuit cases that we can talk about in a bit. But if those cases happen, almost certainly I'm going to get a phone call from the defense lawyer, probably as an expert witness. What did you, Damien Riehl, do in 2019? You did, in fact, write all these things to disk, and the writing to disk copyrights the thing. And then you, Damien Riehl, put that into what is called Creative Commons Zero. So that's the Creative Commons Zero is kind of the equivalent of the public domain, where we say that even though we have copyright in the thing, we are giving it to anybody to use. So we are essentially relinquishing our copyright in those 200 billion melodies. So didn't you, Damien Riehl, put these into Creative Commons Zero that then the defendants in that case might be able to use without punishment? And in fact, the person suing also infringed you, but that's okay because that's in the public domain.
I want to quickly acknowledge and Landon, you can grab as many of those as you like as well. The chat questions, we've got quite a few coming in here. There's some basic good copyright questions. How many notes are required to be a protectable melody? I mean, is what's being generated meet the creative standard for protectability?
Yeah, so that is the heart. And Michael Hughes, I think, asked that question, which is a
Yeah.
beautiful question, and it is the heart of really our work. And it goes to the question of what is a motif that is a very short melody versus what is a longer melody. And what Michael's asking is to ask what the delineation between a motif and a melody is. And musicologists have debated this for millennia. Right? There's really no good answer, and if musicologists can't agree, certainly the courts can't agree. I would argue, but that question goes right to the heart of my work, is that how, a lot of these cases, for example, the Katy Perry case, the melody that was infringed was literally dun, 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 right? Three pitches, dun, 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 quarter notes. So is that a protectable melody? And the Katy Perry jury verdict for $2 million for infringing that simple melody that I just said, that fortuitously happened on Tuesday, and my TEDx talk was on Saturday. So I was able to quickly revise my PowerPoint to say, how ridiculous is it that dun 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 cost $2.7 million? And that goes to Michael's question: is that dun 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 such a short phrase that's common? Should that be protectable? And I would argue no. And thankfully, so that case happened in August, and I gave my TEDx talk in August. Just in the last couple of months, the U.S. District Court, where that case was venued, did a motion judgment as a matter of law post-verdict, finding that short melody was not protectable. That was, of course, I think in February. My TED Talk was 6 months earlier and had received, right now it's about 1 million people have seen my TEDx talk, both on the YouTube and on TEDx. And I also gave a bunch of interviews with a bunch of other musicologists and other folks. So a lot of music folks are talking about my project and what it means for copyright implications. So I'm not going to claim that there was a causal effect on me bringing this up and the U.S. District Court, but I will say that the District Court changing tune, that U.S. District Court had actually a year earlier denied summary judgment on the very same issue that it reversed course on post-verdict after my TEDx talk. So there's, I'm merely speaking correlationally, and correlation is not necessarily causation, but I'm hopeful that the message that I'm bringing is actually reaching some ears and is actually making a difference. So that Katy Perry case is number one. The other case that happened after my TEDx talk was the Led Zeppelin case, which people might have heard about. That Led Zeppelin was alleged to have infringed on their Stairway to Heaven. I alleged to infringe a song called Taurus. And the Ninth Circuit has actually found that is not a protectable melody either. So anyway, so during my TEDx talk, if anybody watches it, I said, almost 100% of the time defendants lose. Post TEDx talk, I'm batting 1,000. So far, all the defendants have been winning.
So eventually, we can start inferring that it's not just happenstance that everything's changing soon. So those judges out there may be, watching TEDx.
Well, and that was actually my goal. So when I initially thought of this project, I thought, this is going to be a law review article, right? I'll write a law review article. Maybe somebody will read it and actually change the law that way. And then the TEDx folks approached me and said, we'd love for you to do a TED Talk on this. And I thought, of course, right? Because the law clerks that work for the judges are going to watch that TEDx talk and they're going to push it to the judges. And the lawyers who are litigating this thing, no better way to make these days to make the law change than to get a venue like a TEDx talk to be able to make it happen. So anyway, so I still haven't written my law review article, but I think I've been much more effective with my TEDx talk. And by the way, my law review article is in progress at my website, allthemusic.info. We have a frequently asked questions that, if printed out, has about 50 pages worth of detailed legal argument as to why everything I'm saying, and with case citations, et cetera, why everything I'm saying has some merit and should be pushed forward.
So another question from everybody out there is the question regarding whether or not the computer is actually the author of the billions of generated melodies. And I don't know too much about generation and authorship in that regard.
That is another beautiful question. I would say that I give a lot of these interviews, and those two questions are really the heart. So I kudos to both the questioners. I think Kelly is the one who asked this. So she or he, I guess, is going to, when we hit the button on run, is that much akin to a photographer hitting the shutter on the photograph? So are we the author of the thing, or is the camera the author of that photo? Well, I would argue that we, as the humans that hit run, that had programmed the thing and hit run to make the thing happen, we are the human authors. And I guess more accurately, All the Music LLC, my limited liability corporation, the person hitting run is an agent of All the Music LLC. Therefore, the LLC is the actual author, which is important for terms of if we ever do get sued. I want the LLC to get sued, not me independently to get sued. But I will say that the question that Kelly asks is really in fierce debate right now, because the US Copyright Office has taken the opinion that if I were to try to register all the music, my 200 billion plus melodies with the Copyright Office, they would almost certainly deny it, because under the copyright it's not even a regulation, and so it's not gone through the formal rule-making process, but at least under their guidelines, they say that that it has to be human created, and that machine-created works cannot be copyrighted. So to answer Kelly's question, if you were to ask the U.S. Copyright Office, they would say no, that cannot be copyrighted. But if you were to ask the UK, the United Kingdom, recognizes machine-generated copyright. So that brings up an interesting legal question, because under the Berne Convention, any signatory to the Berne Convention, which includes both the US and the UK, any one signatory has to recognize the copyrights of another signatory's copyrights. So if the UK recognizes our machine-generated copyright, which it does the US therefore have to recognize my machine-generated copyright? And so I would say that to the quick answer to that is there are two possibilities for whether my works are copyrighted. Number one, they are copyrighted. So all 200 billion are copyrighted. And if so, I put them all into the Creative Commons 0 for the public domain. Anybody can use them, okay? Number two option is they are not copyrightable. And then the question is, why are they not copyrightable? And if the answer is because they're just math, and math is facts, and facts are not copyrightable, then anybody can do it anyway, right? It's in the public domain naturally because they are fact-based, and facts cannot be copyrightable. So I would argue under either argument, either A, copyrightable, or B, not copyrightable, every melody that we've created is in the public domain for people to be used freely without being sued over.
So if they come up with the argument that it's essentially, you can't have the copyright because it's computer generated, does that then put any onus on the other side that's saying that they created a copyright material to affirmatively say, we didn't create this using any type of computer generation? And to what extent does computer generated melodies come into play? If they're saying copy and paste different sections, does that suddenly make their copyright invalid? Thoughts?
100%. And I would argue that you are spot on right, because the argument we're making is melodies are fact. Melodies equal math equals fact. And so the real tangible example is the Katy Perry melody that she got sued over, the dun 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 dun. That shows up in our All the Music data set 8,196 times. So that dun, 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 that's length, I think 8, if I'm remembering correctly, and ours is length 12. Therefore, it shows up 8,000 times in our thing. So I would argue if the Katy Perry case were post All the Music, why should Flame, the plaintiff in that Katy Perry case, get something that a machine spit out at the rate of 8,000? Should he get copyright on something that is factual, that is just generated programmatically?
And one of the questions here is, would it be useful to submit them to the U.S. Patent Office to have them formally rejected?
I thought about that, and actually I work in Washington, D.C. I pre-COVID, I spend Monday through Wednesday in Washington, D.C. and then come back on Thursday through Sunday and do it over again the next week. So I actually just work a few blocks from the Copyright Office. So for a few months, I had the hard drive, which is actually right over there, the hard drive of all the music. So you can actually hold in your hand, it's the size of a deck of card, 200 billion melodies. So I actually had that hard drive in my bag, and I thought, I'm going to walk over there one day and just hand it to the clerk and watch the big eyes saying, what's this? Oh, it's 200 billion melodies that I'm copywriting. And I thought about doing that, But then I thought, okay, one, almost certainly they'll reject it. So what do I do next? Okay, then I would sue them for declaratory judgment in a district court, saying, you know, you rejected this improperly. And then I thought that's a lot of work and a lot of distraction. So that's option A, to actually file it with the Copyright Office. But really, option B is probably better, because you don't need to formally register with the Copyright Office. Under the copyright law of 1988, post 1988, in 1988, as soon as it hits that fixed tangible medium, it's copyrighted automatically. You know, I don't need the Copyright Office to put their stamp of approval on this. It's already copyrighted. So any litigation that happens from here on out, they're still going to be able to point to my work with or without the Copyright Office's approval, or not.
Carl's asking some of the registration questions, which I was wondering myself. I mean, 2 billion, you have to submit a specimen for each registration, don't you? And as Carl was pointing out, it's $35 per melody. Wouldn't it?
Maybe. And so, yeah, so that's the question. So if I register my CD with the Copyright Office and my CD has 100 songs on it, do I have to pay $3,500? Or is it just the single registration for $35? So I would argue that my hard drive, it doesn't have 100 songs, it has 200 billion songs. You know, would that be conceptually different?
And then one question, you know, you had talked a little bit about, I think, the UK and the fact that you could go through computer-generated melodies would go through just fine. Would there be any benefit? I mean, is this something you've looked at, is to have them registered over in the UK? Does it need to be, do you need to go over to the UK and run the program again?
I would argue that it's anywhere it is published, quote unquote published. It is therefore, and so with the internet, you know, I'm published everywhere. People have downloaded all the music data set from all over the world, and we've gotten press, like a bunch of The Independent out of the UK, the Times of London, and a bunch of UK. The BBC has actually reached out to us they want to do an hour-long documentary on our project and what the nature of music and copyright and machine-generated music and that kind of thing. So anyway, there's big interest in the United Kingdom in our project. So almost certainly our works have been downloaded in the United Kingdom, therefore published in the United Kingdom. Therefore, under the Berne Convention, I don't think I need to register anywhere. It's already effective.
And I'm going to jump back a little bit, because we had the question about whether or not the computer was the author. Breaking it down a little bit more with computer generated, if you had one group that designed the program and a different group that ran the program, who's the author? That's more of a theoretical question, but
yeah, that's a really good theoretical. I guess one possibility that there would be joint authorship, much like co-authors for a law review article, for example. They have joint independent authorship where each of them, regardless of whether I submitted 3 words to this manuscript or half of it or 98% of it, I'm still a co-author with the other people. So I guess one interpretation would be that all of the programmers that contributed as a team are co-authors to it. I would say that for our particular project, All the Music project, my collaborators Noah Rubin and we are the the agents of All the Music LLC, which is the formal author of the project of the all of 200 billion melodies.
I'm going to break in with the CLE code if that's okay. We've got a number of call-in listeners as well. I want to respect their time and just note that the CLE code is 306025. 306025.
And Carl Christensen had a really good point about only humans can be authors, and he cites the monkey photo case. And for anybody who doesn't know, the monkey selfie case is that a wildlife photographer set up a tripod in the jungle. A monkey comes up to the tripod and literally takes a selfie of the monkey. The monkey takes a selfie. And so there's a question as to whether that photographer that set up the tripod actually has ownership of the copyright, or whether the monkey has ownership of the monkey selfie. And the court in that case said that nobody had copyright to it because only humans can be owners. So at least under the US law, under the monkey selfie case, All the Music LLC, through its human agents, was the author of the 200 billion.
And that case actually drives me nuts, because of course, going through that case, all of the presumptions that I'm hearing from every side are, well, who owns the copyright? The idea is, no, there doesn't have to be a copyright. Like, it could be something that was created and nobody owns the copyright to.
That's right.
And I think that unfortunately with the way that our copyright system works is We presume that there's a copyright. There's little to no chance that nobody owns this. Everybody has to own, well, everything has to be owned by somebody. And I think that's one of the problems, of course, with our system. So I really appreciate the work that you've done on this too. If there is an ownership, we'll give it to the public.
That's right, and really your point right there goes to a larger larger point where I talked with a Juilliard trained copyright lawyer, violinist from Juilliard, who said that really this should be about the love of making music. Musicians should be thinking as they make a song, this is something that I can sue somebody over, right? They should be making song for the love of music. And he said it's these "you stole my melody" lawsuits. They're a circular firing squad, because yeah, I might sue somebody today, but I'm going to get sued tomorrow. So it's so it's ridiculous, and especially for this Juilliard trained violinist, he said, and especially over these stupid melodies, right? These stupid simple melodies, right? This isn't Stravinsky, right? This isn't a 12-tone aleatoric, thing that is, almost nobody can accidentally step on. This is a diatonic, only 7 notes. So to sue over 7 notes, over something that nobody should own, and nobody should own those 7 notes, is what I and many other musicologists argue. You're right, that we should be making music for the love of music and not worried about suing people. And because this is a CLE, we should take the legal aspect. I have been under the presumption that, I said, people shouldn't be spending money on lawyers to actually sue people. But a lot of my New York entertainment law folks say almost all these cases, the "you stole my melody" cases, are on contingency fee basis. So this is, lawyers reaching out to songwriters who don't have money to pay lawyers, right? Certainly Flame that sued Katy Perry. Flame is a Christian rapper that almost has no money. So that guy took it on contingent. That lawyer took it on contingency, hoping to make some dollars on it. So anyway, so that's, go ahead.
I was gonna say you could become a great copyright troll if it were a registrable work, right?
Right, or even not registrable. And that's part of my reason for making so many melodies, and we keep generating more all the time, is that I want to avoid those copyright trolls, right? I don't want somebody to make that argument. Even though I was thinking this morning, if somebody were to do that, because we at All the Music have provided all the code that we've done, and we've open sourced it. We've put it, so if you want, anybody listening could go to our website, download the code, and generate the melodies themselves. So I thought maybe a copyright troll could conceivably take our code and start running and make melodies that we haven't yet made, and then try suing people over those melodies. But I was thinking about this morning, if they did that, bad facts make for bad law. And I would guess that a judge would pretty quickly put the smackdown on that copyright troll, saying no, those are facts, you can't copyright it, which would actually further our cause.
I don't want to get too much in the weeds, but I was just curious, just how do you affix, and maybe folks aren't even familiar with the Creative Commons licensing scheme, so it may be worth chatting quickly about that. But how do you affix the copyright notice to place that in the public domain, or the license agreement, I guess, in the public domain?
So that's interesting. So it's the mechanism, the Creative Commons is what we use. So for those who don't know, the Creative Commons is something that law professor Lawrence Lessig created to be able to allow people to be able to essentially use through contract something that copyright law doesn't allow. So through contract, through Creative Commons, I can say, you can use my work if you cite me and attribute it to me. That's one of the license terms of Creative Commons. To Michael's question, Creative Commons 0 is what we've done, where I have said through license that I give essentially a worldwide license to anybody who wants it, that they can use my copyrighted work for free. So it is essentially a blank check that anybody can use the thing that I assert as copyright. So there is big legal debate as to whether the Creative Commons 0 is actually effective or not, because can I contract with the world to essentially give away every single right that I have in that particular copyrightable work? And that, I'd be happy to be a test case to be able to show that Creative Commons 0 is something. But the way that it worked in practice for us is that we went to the Creative Commons 0 website. I say, I, Damien Riehl, hereby dedicate, the legal term of art, I dedicate to Creative Commons 0 all of my copyrighted work, and then they spit back a receipt saying, you, Damien Riehl, hereby have dedicated all of your works to the public domain. Whether that's legally enforceable or not, I guess a court and jury maybe can decide, but I would argue it's got a pretty good shot of doing that.
I think
And then
some CC licenses have been upheld. It has been litigated, hasn't it?
I think so. Yeah, I haven't dug too deeply, but yeah, I mean, it's a contract. So, you know, if you want to use my thing, you can. I can license to you under any terms I want, including free.
A couple questions here. One of them is, if I write a song, how can I check to see if I might have violated a copyright?
And that is, you guys, your attendees have such great questions. Like I said, those three questions are probably the best questions that get to the heart of what we're doing. Because if you watch my TEDx talk, I talk a lot about a song that is already copyrighted today is a red spot in a grid. If you think about, you know, a grid of rows and columns, some of those spots are taken and some of those are not taken. The red spots are taken, the green spots have not yet been taken. So really the questioner here is asking, how can you find out if it's a red spot or a green spot? It has been taken or has it not been taken? And that's actually one of the All the Music Project's new projects, where we are looking to, we've already created every conceivable mathematically possible melody. So we're working with organizations to plot copyrighted cases, copyrighted melodies into our data set, to be able to say which in our 200 billion melodies, which ones have been taken by copyright versus which have not yet been taken. So which are red and which are green. And then there's actually a third category of which melodies like Beethoven, Bach, Mozart, that were copyrighted, but have now entered into the public domain. Which of those gray melodies overlap maybe the red melodies? And so it gets to the question of if I as a 2020 musician have this great melody that goes dun 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 dun, dun, right? Can I copyright that? Can I extract that from Beethoven? Do I have an independent copyright because that gray melody overlaps my red melody? So really, that gets to the heart of you know, if somebody else uses an All the Music song, which we've made gray, we argue under Creative Commons 0, can they copyright a thing that we've already put in the public domain?
And there was, I think to that, there was another question in regards to subconscious copying. Regarding the subconscious copying, the accused has to be exposed to the original work in some way, shape, or form. Is that correct?
That's right.
Can you talk a little bit about that?
That's right. And I talk about this a bit in the TED Talk, that the term of art in copyright law is you need to have access to. I need to be, as Adam, songwriter for A, Adam writes a song, and then B, Beth, has to be able to access Adam's song for it to be infringing. So for this George Harrison case, George Harrison had to have accessed the Chiffons song. And in the depositions and in trial testimony, George Harrison said, I don't remember ever hearing that song. You know, he said, I guess maybe I could have, but I don't remember ever hearing it. And I certainly wasn't thinking of the Chiffon song when I made my song. And that's when the court said, well, you probably heard it somewhere because it was a super popular song. Therefore, you subconsciously infringed the thing. And that is an untenable position because now with the internet and Spotify, anybody with a YouTube account and anybody with a Spotify account has quote unquote access to every single song. And for context, you know, there are about 200 billion songs with a B, 200 billion songs out there. Is that right? No, it's maybe not that many, but there's a lot of songs out there. And now with the All the Music Project, anybody listening to this podcast has access to my 200 billion melodies that I've put into the All the Music, right? So the idea that anyone could subconsciously infringe anything they have access to is absurd. And if you think about it, if you were to defend Katy Perry, you know, essentially that subconscious infringement, you have to prove a negative. You have to prove that you've never done something. And under philosophy, proving a negative is philosophically impossible. You know, how do you prove that something never happened? You can't do it. And how can Katy Perry prove that I, you know, didn't hear the song over the loudspeaker at the supermarket? Right? It's impossible to show that. So 100% of the time, under this subconscious infringement, they, you know, a jury and a judge can pat that defendant on the head saying, oh yeah, we believe that you didn't consciously do it, but you totally heard that thing because, oh, it's super popular. Flame said, I've had 3 million views on my YouTube, even though he couldn't show that Katy Perry or any of her co-songwriters actually heard the song. He said, well, the 3 million shows that it was popular, therefore she probably subconsciously infringed. And that's what the jury hung their hat on. So as part of my All the Music project, I gave I talked with a popular YouTuber, and he, at the end of his YouTube thing, said, hey, let's get this YouTube video up to 3 million views, because that appears to be the threshold for what is to be get access to the thing. So if this YouTube video gets 3 million views, therefore the 200 billion, now everybody has access to it, which just goes to the absurdity of this whole access and subconscious infringement thing.
So I suspect I'm really going to be asking a question about, this is essentially what all the defense attorneys out there are actually doing. But when you talked about Bach, or if you talk about Beethoven, or a lot of those classical songs that are in the public domain, I assume that a lot of the defense attorneys are doing the work of going back into some of those classic songs and saying, all right, can we find this set of 7 notes anywhere in these historical songs in this music, looking probably multiple nations, their history, their background, trying to find those melodies anywhere. And I'm amazed that there can be so many tunes or melodies that aren't found somewhere in that classical music.
That's 100% right. And lawyers have done that in the past, but it hasn't really, it's kind of fallen on lay non-musician jurors and lay musician, non-musician judges' deaf ears. To use a metaphor that I didn't, as a non-musician, you look at those two, the Chiffons and George Harrison, and you think, well, they must have copied, right? So the fact that they say, well, yeah, Beethoven also used the thing, doesn't matter to the lay jury or the lay judge, because they say, well, they're too similar to them have not copied. So you're right that lawyers have in the past said, look at these 24 classical pieces, all of which used the same simple motif. They've done that, but it's really not been super successful. My hope is that post all the music, maybe it's more successful, because we not only, there are websites out there where you can do the work that you just asked about. The Stanford Computable Law, you can put in a sequence of pitches and it'll show you all the classical songs that come out with those sequence of pitches. And then there's the hooktheory.com is one that does the same thing for pop songs. So if you put in, say, a chord structure, it'll show you all the songs that use those chords. So anyway, we are currently in the process at All the Music of overlapping those data sets with our data set to essentially try to fill in the red spots and the gray spots in our data set for defense lawyers to be able to use in future copyright cases.
And in that data set that you're talking about with the red, the green, the gray, does that look at timing included in those dates and times? Because obviously if you got a red, but the infringing song was actually created before the copyrighted song, I think that you got timing issues. How much time and effort are you putting into trying to find the date that box went red?
The short answer to that is not much time. So I'd mentioned earlier in this podcast that I've made $0 on this. In fact, I've spent thousands and thousands of dollars for the benefit of the world to do this project. So so far all the music project has run a solid deficit of thousands of dollars. So because this is a passion project, which is making $0, and because so for that reason, we've not spent a ton of time in doing this. And I think you're right that being able to do timing of what is red versus what is green versus what is gray, the timing of that is certainly worth doing for somebody who's inclined to do it. We would love for somebody to be able to build upon our data set to be able to do that work.
Is there, speaking of things being out in the comments, is there thoughts or ideas regarding kind of crowdsourcing that, putting it out there for people to update, make it a wiki or something to that effect?
Yeah, so yes, and we've talked to several organizations to actually do that work, and we've had several meetings with a particular organization that I'm hopeful is actually going to do that work. So yes, we hope that that's going to happen. The second thing is somebody else had suggested, much like the monkey selfie case, you could actually create a website. So we are currently in the process of, on the All the Music website, you will eventually be able to go to, there's a keyboard on the screen where you plunk out a melody on the keyboard, and it'll display all of the melodies in our All the Music data set that contain the thing you just plunked out on the screen. So somebody had suggested maybe we put a bunch of keyboards in zoos with a bunch of monkeys, that the monkeys just mash out a bunch of melodies on the keyboard, and then we've accessed, okay, this is where that melody shows up in all the music data set. Therefore, all of those turn gray automatically, because under the monkey selfie case, that is not copyrightable. Therefore, it is in the public domain. Therefore, anybody can use the thing. So for anybody, who is the author? Maybe the monkey's the author and it's not copyrightable. Similarly, go ahead.
Oh, and I was going to say, well, to that, that's similar to what you talked about, the difference between a photo versus a melody is, even though the monkey might have hammered out on that keyboard, that doesn't necessarily pertain to whether or not the monkey can own that copyright, because somebody else could actually do that and then own the copyright.
That's right, independently. But if they had access to all the music data set, which millions of people have now seen and heard my talk, that know mathematically I've exhausted the things. If they've had access, they'll know that that monkey probably made the melody. Therefore, they're on notice to that they didn't actually independently create the thing.
Does anybody have to actually have listened to the melody? Because I know you have it out there, but I don't know how many people have actually listened to the billions of melodies on there.
That's a really fine question, and that's it kind of gets to philosophy, where I don't know if there's been a case that it's been addressed this, because by our describing this over an hour, what every one of my melodies sounds like without actually having heard every one of my melodies. So there's a philosophical question that you have mens rea, you have knowledge of the thing that you've never heard.
All right, great, guys. We are 22 minutes over time, which I really appreciate. I've got the Naruto image up if folks were wondering what all the fuss was about. That's Naruto, the monkey selfie. Thanks all for joining us today and sticking with us through the end of the discussion. Damien, thank you so much. It was a really great conversation. Very, very interesting, and we look forward to developments here. Keep us apprised of what's going on. We will have you back, although I'm sure your insurance carrier doesn't love your business model. Let us know when you get sued, and we'll have you back for that for sure. So.
That would be awesome. And next time we talk, maybe we could talk about my work at Fastcase, which is my day job, which is a lot of fun too.
Absolutely. Yes. I'm very eager to learn more about that. Very excited about your roadmap over at Fastcase as well. Join us next week. We're going to be talking with Joe Colucci from Procerus, maker of our least popular online service ever, the legal tech assessment. We'll talk about why that's so unpopular. The tech assessment is your way of demonstrating your competence in Word, Excel, and PDF. And it's been a challenging service for us to offer, but we'll talk with Joe next week about why you should take the legal tech assessment.
I couldn't hear that. Did you say competence or incompetence? Because the incompetence seems to be the more common.
Must have been a glitch in the audio there. Sorry for that. So join us then. As I say, stay tuned too for the triple LT conversation. That one will certainly blow up, but there's been some movement on that front as well from the Supreme Court. So we will take a look at that issue in an upcoming session as well. So thanks again, everybody, for joining us. Have a great rest of your day.